I'm Emily Mesher, and I am the daughter of a residential school survivor, and I was married to a residential school survivor. I'm going to read from the aftermath of the settlement agreement. During the 1990s, the number of civil lawsuits against Canada and the churches that ran the schools steadily increased. Many of these claims were combined into class actions that were certified by provincial courts. In May 2005, the Government of Canada appointed former Supreme Court Justice Frank Iacobucci as its chief negotiator to help reach a settlement agreement among the many parties involved in litigation: representatives from the Aboriginal communities, church groups, the federal government, and survivors represented by various law firms. The parties reached an agreement in principle in November 2005. The details of the Indian Residential School Settlement Agreement were finalized and approved by the Federal Cabinet on May 10, 2006. The thousands of legal claims made against the federal government and the churches were concluded and settled under the terms of the settlement agreement. Because the settlement agreement would involve the termination of a number of class action proceedings that the courts had already authorized, it was necessary for courts in most provinces and territories to consider whether the settlement agreement was a fair resolution of the claims, and in particular whether it adequately protected the interests of all the class members. The settlement agreement included a common experience payment, CEP, for everyone who attended one of the residential schools listed in the agreement. In addition to the CEP, an independent assessment process, IAP, was established to pay compensation to those who suffered sexual or serious physical assaults, such as severe beatings, whipping, and second-degree burnings at the schools. The process also included compensation for assault by other students if they were the result of a lack of reasonable supervision. The IAP was designed to be an easier process for complainants than litigation. Hearings are held in private with cultural supports for the claimants and health supporters provided by Health Canada. In contrast to the protracted nature of much civil litigation, hearings are supposed to be held within 9 months, with decisions due shortly after the hearings. In their statements to the Commission, some survivors have expressed concerns about the IAP abuse hearing process because it did not allow them to face their abusers directly. Bernard Ketchaway, former student at Pine Creek Residential School in Manitoba, told the Commission, quote, and my abuser's still alive. I think she's 89 years old, according to when I went to my hearings 3 years ago. I wanted her so badly to come to that hearing, but because of her age and because of her, incompetency, she chose not to be there. I would have loved for her to meet her at that time, to basically say, to say whatever it was that made her do things to us. I was going to say, I forgive you, but I never got a chance to say that, unquote. Other claimants, such as Amelia Galios-Thomas, a former student at Seashell Residential School in British Columbia, criticized the IAP's delay in hearing and settling claims. Here's her quote. I've been waiting 5 years now for my appeal, and it hasn't happened yet. And it's almost time for them to stop giving the money out to us. And they opened up all our wounds for what? To turn us all down? And some people are dying. My sister's doing drugs, 'cause she's tired of waiting. She's living on the streets. So why did they do this to us again? They hurt us again. They shouldn't go back on their word to us. They already hurt us. Stop hurting us. End quote.